Dana Sparks, broker of Maximum One Greater Atlanta Realtors, and this week's contract tip has to do with sending notice per your contract. Just a reminder, on both sets of contracts, the GAR form and the RE forms, both packages where it talks about notice and sending notice, both contract forms specifically state that if you are sending notice by email, it must be to the email address as is on the signature page of the contract. So if you send an offer or receive a counter offer, or you are communicating back and forth with an agent and you get an email with that, if you are sending notification, for example, terminating a contract under due diligence, under whichever contingency or whatever, make sure that the email address that you send that notification to is the email address as written on the purchase and sale agreement signature line, regardless of the method by which you have been communicating with the other agent. Again, it specifically states, both sets of contracts, that notice is to the email address that's on the signature page, the fax number that's on the signature page, or a mailing address. One more tip along the lines of notice. As agents, whenever you are communicating something on behalf of your client to the other agent to get information to the client, don't do it by email. Make sure you guys use the notification forms. And again, both sets of contracts, GAR and the RE forms, have a notification form. The GAR form is F-135 and it is called notice. And the RE form is RE-260, and that is called notification. So that would be the specific form that you would use. A lot of times as agents, you guys are communicating by email, agent to agent. And remember that as an agent, you cannot bind the parties to terms, and formal communication needs to occur. Again, this notification form, sending something on that will help you. Let's say that, for example, you use the special stipulation that I talked about in a previous video about buyer's due diligence period to begin when the seller has the utilities on, and in that special stipulation it talks about that the seller must send notice to the buyer that the utilities are on, and that's how our parties know that that's when the due diligence period begins. Well, that notice needs to happen not through email from listing agent to buying agent to selling agent, but really should happen on one of these notice forms so that the seller is formally notifying the buyer that the utilities are on. That's just one example. There are many examples, again, when you as an agent typically communicate with the other party's agent by email. And just remember to comply with the contract when it talks about notice and notification. Two things: make sure you use the notification forms. You will be better protected should there ever be an issue. And number two, make sure that if you are sending notice by email, that you do use the email address that is written on the signature page of the contract. If an agent does not include an email address on the signature page of the contract, you need to do an amendment to determine what that official email address is per the notification terms of the contract. Thank you so much for watching. Again, Dana Sparks, broker of Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education.